Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. All right, folks, let's get into this video. This is a really important video. Has to do with racial profiling. And it specifically has to do with the National Guard and ICE and so on in the state of California and what they've been doing with their deportation efforts, right? So a few months ago, a California judge started hearing evidence about whether the Trump administration was racially profiling Latinos. And the judge in that case handed down a decision. Hey, family, do you believe in the work we're doing? Does our content speak to you? Do you appreciate our in-depth legal analysis and political commentary from an African-American perspective? Do you believe it matters to our community? Then don't just watch from the sidelines. Please click that membership button and become a member of the 2% Club today. That's right, we need just 2% of our subscribers to become channel members. For just $4.99 a month, that's less than 20 cents a day, you'll help us keep creating powerful content that defends our democracy, demands justice, and develops a strong African-American community. But if you want more, at $9.99 a month, which is only 33 cents a day, you'll get access to exclusive members-only live streams, bonus content, and behind-the-scenes updates. And for just $14.99 a month, which is under 50 cents a day, our top-tier members get access to live Zone calls, strategy sessions, and a direct voice in shaping this movement. We're not just building a YouTube channel. Folks, we're building a movement based on righteousness and justice, just what our community needs in a time of disinformation and division. So if you believe in what we're doing, click the membership button and join now. Become a member of the 2% Club today. Let's build something powerful together. And I'm going to walk you through that decision, and here's why. I am a practicing attorney. That means I still go into the courtroom, I still practice law, I have clients, and so on. And a lot of those cases have to do with racially profiling my client. And not only do I represent those folks in criminal court, but my firm also does civil rights law. So this opinion on racial profiling is really important for my clients, who happen to be, for the most part, African Americans. There have been some folks who have asked the question on our channel, why is this important for blacks? Well, it's important for blacks because oftentimes when opinions are handed down from circuit courts or from SCOTUS, sometimes from district courts, they impact everyone, especially black and brown people. So what SCOTUS does relative to Latinos can have and oftentimes does have an impact on African Americans. And it would be remiss of me as a practicing attorney for me not to understand how these cases may impact my clients. Now, if you don't want to know how these cases impact you and you're an African American, then just don't watch the video. But if you want to be informed, if you want to know what's going on and you don't have this crazy thinking like some blacks have, that what the court is doing to Latinos, what the court is doing to other people of color is not the business of African American people, that you have become a victim of disinformation. And it's really common sense, if you think about it, that we as African Americans need to know what the court is doing anytime the court deals with the issue of race. Because our race has been weaponized against us since we've been here. And so we need to stay abreast and stay informed from experts, not from content creators who don't know jack about what is going on really in the court system, other than what I've seen some of them try to read court opinions and interpret the law, and they are all wrong. They're misleading people. Oh boy, it's like a content creator who's never, ever, ever studied and practiced medicine trying to read an x-ray. And yet folks just pile up on their YouTube channels to hear them read those x-rays or read some court opinion. I mean, it's just crazy. I don't know why people do it. It's because folks are oftentimes anti-intellectuals. African-American people can be anti-intellectual, meaning I don't want to hear anything the expert got to say. I'd rather get it from my favorite TikToker or get it from Instagram or my favorite YouTuber who I know they don't know anything about it. They've never studied it, never been to school for it, but I still rather hear from them. We got to do better as a people. We got to do better. I'll just be honest with you. Anyway, the question has arisen. Folks have asked me, did SCOTUS just sanction racial profiling with this case that I'm talking about? Did SCOTUS just sanction racial profiling? Because we know racial profiling is unconstitutional, right? Racial profiling, mistreating someone on the basis of their race, that is not constitutional. So did SCOTUS just sanction racial profiling with this case that we're going to go over? Well, the answer is no. SCOTUS did not just sanction racial profiling. Instead, SCOTUS, in a sense, sanctioned racial profiling 50 years ago. Let me say it again. SCOTUS didn't just now sanction racial profiling. I've even seen some lawyers saying that. No, instead, SCOTUS sanctioned racial profiling 50 years ago. One could make a strong argument, and I'm going to make that argument in this particular video. All right, so let me, first of all, just sort of walk you through what this case is all about and why it's now on the radar screen. And let me start with explaining to you something you may have heard called the emergency docket or the shadow docket. What exactly is that? Because a lot of the cases that SCOTUS has handed down in favor of Trump have been on the shadow docket. So what is the shadow docket? Well, the shadow docket are the cases that come in front of SCOTUS, and the cases don't ask SCOTUS for any permanent relief. They typically ask SCOTUS for some temporary relief, like an injunction or a stay. Okay? Now, an injunction or a stay is basically when litigants ask SCOTUS to stop something from happening, to prevent someone from doing something. And those typically come to SCOTUS while the case is pending in federal court. Now, let me explain. And this is SCOTUS blog here. Let me read this very quickly. This is the Supreme Court's emergency docket, also known as the shadow docket, consists of applications seeking immediate action from the court. Unlike the merits docket, now the merits docket is the docket of cases where they are asking for something permanent to be done. Again, the emergency docket or the shadow docket, they're asking for immediate relief, but it's temporary. It's typically temporary, all right, while the case is pending. So these cases are handled on an expedited basis with limited briefing and typically no oral argument, and the court often resolves them in unsigned orders with little or no explanation. This page shows significant emergency applications that have been filed during the current term. Applications involving the death penalty are shadow in gray. Applications involving all other topics are in white. So again, the shadow docket is when the court is handing out immediate relief that's typically temporary, whereas the merit docket is where they're deciding the cases on the merits, and they are allowing for full briefing. They are allowing for oral argument. They're doing their behind the scene stuff, and they're issuing a permanent decision. All right. That's the merits docket. So the court has been giving Trump a whole lot of what he's asking for on the emergency docket. It's really their way of getting around some of the sticky issues that Trump has been going in front of them with. All right, now, I am not going to try to pronounce this judge's name. She is an American. Her parents, however, are from Ghana. Okay, so I can't pronounce. I could try, but I'm not gonna even mess it up. Okay, but she handed down what is really an important opinion having to do again with ICE rounding up and deporting Latinos. Now, let me explain it to you. So we remember some time ago, several months back, when ICE started rounding up people across the country, including California. You remember when they sent the National Guard and sent some Marines to L.A. Okay? Well, one of the things that ICE was doing was what's called these sort of roving patrols, where they were just popping up on people and basically accosting those people. And the question becomes whether or not they had or have reasonable suspicion to stop and accost those people. Because the Constitution requires, our law requires, the Fourth Amendment requires that they have reasonable suspicion before they stop and question people. Those are called Terry stops. And they have to have reasonable suspicion, but ICE was not doing it. And so some of those Latinos sued ICE, specifically sued Kristi Noem. I think that's how you pronounce her name. All right. And so the judge that you see there, she had a hearing and she received evidence, and she basically said that they did not have reasonable suspicion because they were using 4 factors that she felt did not form the basis of reasonable suspicion. All right, so when she handed down her decision, the Trump administration appealed her decision to the Ninth Circuit. So now the case is in the Ninth Circuit, and they're going to issue an opinion on the merits of the case, on what the judge decided. They're going to look at the judge's ruling, look at the record, look at the evidence, and decide if the judge abused her discretion in her decision, or whether or not there was some constitutional violations that would warrant overturning what the judge said. Now, the thing that the Trump administration did, in addition to filing an appeal, is they filed an application asking SCOTUS to stay, that means stop, the judge's ruling that they could no longer just ride up on Latinos and accost them without reasonable suspicion. All right. She told ICE, you can no longer do that based on these factors. We'll see what those factors are in just a moment. All right. And so they filed an application on that shadow docket that I just explained to you, the Trump administration filed an application for a stay. They're asking SCOTUS, they did ask SCOTUS to stop the judge's opinion, which stopped them from doing those stops without reasonable suspicion based on the judge's opinion. And so SCOTUS issued an opinion on that, approving Trump's application for a stay. So the judge's opinion is now stopped, and Trump can continue. They can continue rounding up people, stopping people without the basis of reasonable suspicion. Okay? Now, here's what SCOTUS issued on the shadow docket. So it's not a permanent decision because the case is with the Ninth Circuit. The Ninth Circuit has to render its opinion, and then there will likely be a writ of certiorari, where that means where whoever loses in the Ninth Circuit will ask SCOTUS to issue a permanent opinion. Because again, this opinion that we're about to look at here, it is temporary. It was just simply put in place so that Trump could continue with his immigration enforcement in LA, in the state of California. All right, so nobody signed this. However, Justice Kavanaugh wrote a concurring opinion explaining why he agreed with the other 5 conservatives. And Justice Sotomayor wrote a dissenting opinion calling out the Trump administration and explaining why she disagreed with them. All right, so we're going to look at Justice Kavanaugh's concurring opinion, and it starts out this way. The application for stay, all right, that's what Trump filed, presented to Justice Kagan, because each of the Supreme Court justices are over certain parts of the country. So this application was filed to or handed to Justice Kagan, and by her referred to the whole court. So all 9 of them voted on this application. And as you see, it was granted because the 6 conservatives gave Trump what he asked for. And the 3 progressives, the 3 liberals, if you will, voted against it. All right. It says the July 11th, 2025 order, that's what the African-American judge issued, entered by the United States District Court for the Central District of California, case number 225 CV 5605, is stayed or stopped, pending the disposition of the appeal in the United States Court of Appeals for the Ninth Circuit. So they're saying we're stopping it, but the case is going to proceed through the process, and it's now with the Ninth Circuit. And disposition of a petition for a writ of certiorari, that's where you ask the Supreme Court to hear your case. So they said they have stopped this pending what happens in the Ninth Circuit and pending whether or not they ask for, one of the litigants asked for a writ of certiorari, and whether SCOTUS grants it. So it goes on to say, if such a writ is timely sought, should certiorari be denied, in other words, if the Supreme Court doesn't accept the case and refuse to hear it, this stay shall terminate automatically. So then the stay will do whatever the Ninth Circuit ruled, basically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. So this means that whatever, if the stay is, first of all, if the writ of certiorari is accepted, if the court grants the writ of certiorari and agrees to hear the case, then the stay will remain in place. That means the judge's order cannot be enforced, and Trump can continue rounding up Latinos in California until SCOTUS makes its final decision. Okay? All right. So that's all the opinion, just that one paragraph. Because why? You don't get a long paragraph, you don't get a long opinion here because this came through what? The shadow docket. But we did get a concurrent opinion, like I said, from Justice Kavanaugh. And so we're going to look at some parts of it. And this is going to show you that in SCOTUS's mind, racial profiling has been sanctioned by SCOTUS 50 years ago. Not just because of their granting this stay, but the court, in an opinion issued 50 years ago, already said that law enforcement, border patrol, immigration can racially profile people, or race can be a part of the basis of reasonable suspicion. Now, those of us who practice law, we know this already. We know that black people are already racially profiled. You won't find it when we get discovery in a case, when we file a motion to suppress and ask the officer, did he or she use race to form their basis of reasonable suspicion? They're never going to admit it, but we know it happens. We know it happens. And if we took it to SCOTUS, or they took it to SCOTUS, there is a good chance SCOTUS will rule in their favor if they admit that race was a factor. And I'm going to show you why. So we already know it happens. You know it happens. So I don't know why lawyers are on YouTube saying SCOTUS just now sanctioned racial profiling. They've already done so, and it's already been happening. And depending on how this case ends up, will really either limit that racial profile, that sanctioning of racial profiling, or even expand it. And we just have to wait to see what SCOTUS ultimately says. All right, let's go back over. Now, one of the things that Justice Kavanaugh said in his opinion is ICE, pursuant to 8 CFR, Section 287.8B2, says if the immigration officer has reasonable suspicion based on specific articulable facts that the person being questioned is or is attempting to be engaged in an offense against the United States or is an alien illegally in the United States, the immigration officer may briefly detain the person for questioning. All right, that is a federal regulation that was issued by INS and the Department of Justice. So Kavanaugh says, based on that authority, an immigration officer can stop anyone who is suspected of being in the country illegally, so long as they have reasonable suspicion. So he agreed with the judge, the African-American judge. He agreed with her that reasonable suspicion is needed. They just disagree on whether or not race can be a part of what forms the basis of reasonable suspicion. Okay, let's keep moving. The reasonable suspicion inquiry turns on the totality of the particular circumstances. Really important. And that's why he has it in his concurrent opinion in quotations. The totality of the particular circumstances. Brignoni Ponce, 422 U.S. at 885, note 10, and Arizu, I think is the way you pronounce this, 534 U.S. at 273. Those are two previous cases. And the one, the Brignoni Ponce, 422 U.S. at 885, note 10, that one right there is the one that made racial profiling constitutional. That is where SCOTUS itself said that race can be a factor in establishing reasonable suspicion, and that case was handed down in 75. And if my math is correct, 75 to 2025 is 50 years. So this sanctioning racial profiling on some level has been the law now for 50 years. Okay, let's keep working it. So here's where Justice Kavanaugh tells us the four things that bothered the African-American judge. district judge. So he writes, a federal district court found that these raids were part of a pattern of conduct by the government that likely violated the Fourth Amendment. Based on the evidence before it, the court held that the government was stopping individuals based solely on 4 factors. These 4 factors were what were objectionable to this judge, and to the litigants, and to the Latinos who were being stopped. Number 1, their apparent race or ethnicity. Number 2, whether they spoke English or Spanish with an accent. Whether they spoke Spanish or English with an accent. Number 3, the type of location at which they were found, such as a car wash or a bus stop, and the type of job they appeared to work. Concluding that stops based on these 4 factors alone, even when taken together, could not satisfy the Fourth Amendment's requirement of reasonable suspicion. The district court temporarily enjoined the government from continuing its pattern of unlawful mass appeal arrests while it considered whether longer-term relief was appropriate. All right, that's what Kavanaugh wrote. So he now begins to explain why, in their opinion, the 6 out of the 9 justices, he's explaining why at least he voted with the other 5, and why in their minds the judge, the district judge, the African-American judge, is wrong. So he explains, to stop an individual for brief questioning about immigration status, the government must have reasonable suspicion that the individual is illegally present in the United States. All right, we're not going to read all that case law citation. Jump down to reasonable suspicion. Reasonable suspicion is a lesser requirement than probable cause. Yes, probable cause is a higher standard, and it's required before law enforcement can search or arrest someone. But just to stop someone, they at least need reasonable suspicion. Now, whether an officer has reasonable suspicion depends on the totality of the circumstances. So you can't just look at 1 factor or 2 factors. You got to look at the total circumstances, everything that's going on. And whether they have reasonable suspicion is based on everything, the totality of the circumstances. And so now the next slide that we look at, you're going to see what those totality of circumstances are or were in Justice Kavanaugh's mind. And you're going to see here why they decided the way they decided. Here those circumstances include that there is an extremely high number in percentage of illegal immigrants in the Los Angeles area. So that tops his list of circumstances that justified taking race into consideration when you're trying to decide whether or not there's reasonable suspicion. He comes out the gate, and we can assume the other 5 conservatives came out the gate with the issue of the number of people in the country illegally. All right. So goes on to say that those individuals tend to gather in certain locations to seek daily work. That those individuals often work in certain kinds of jobs, such as day labor, landscaping, agriculture, construction, that do not require paperwork and are therefore especially attractive to illegal immigrants. And that many of those illegally in the Los Angeles area come from Mexico or Central America and do not speak much English. So he lays out all these circumstances that really single out Latinos, right? And, his attitude is we can't overlook these circumstances. These circumstances must be taken in consideration when you're talking about the totality, when you're required by law to look at the totality of circumstances. All right, so he goes on to say, to be clear, apparent ethnicity alone cannot furnish reasonable suspicion. Now, that's really important. So he says ethnicity, apparent ethnicity, or race alone cannot furnish reasonable suspicion. So had ICE said, we stopped them just because they are Latino, then that would not have been reasonable suspicion. Now that opens a can of worms, okay? Because, and we've seen it so many times, all law enforcement does is just give you a few reasons. And with those other reasons, then they're able quite often to say or convince a judge that they have reasonable suspicion. When everyone knows the real reason was because of the person's race. Again, a lot of the lawyers who are opining on this case are not practitioners. They don't practice. They do other things. You know, lawyers, not all lawyers, maybe not most lawyers are litigators or are actually in the courtroom dealing with clients, dealing with prosecutors, dealing with opposing counsel. So some of this, they don't know. They don't see the dash cam, the body cam that we see, where clearly our client had been racially profiled. But when we get to paperwork, when we get to discovery, there are other reasons that are used, or when we file a motion to suppress and we're able to cross-examine that officer or officers, again, most of the time they're not going to admit race, or it's not going to be just race by itself, because they know these cases as well. They know that Brignone case, that Brignone-Ponce case. They know this. They received that training in the academy or in, subsequent classes after becoming law enforcement. So to be clear, he says, apparent ethnicity alone cannot furnish reasonable suspicion under this court's case law regarding immigration stops. However, it can be a relevant factor when considered along with other salient factors. And there it is. Not by itself, not race alone, but race can be a factor, a relevant factor, which therefore means that racial profiling has been going on and sanctioned by the court for quite some time. And here in Texas, we have case law that literally says that race alone, just mirrors this, cannot be the basis for reasonable suspicion, but with other factors, it can be. Now, in this particular case, the court goes a little further when it talks about speaking English with a Spanish accent or speaking Spanish or going where day laborers are. And so, that is literally singling out Latinos. It would be the same as if the court said, let's say it involved black people, right? Let's say, and this, I'm telling you, this could happen. 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 I think it may. So let's say Trump says, okay, now it's time to go after drug dealers. And a lot of the drug dealers are in the African-American community. And so then law enforcement, some task force or whomever, whatever agency he would use, starts going into the black community and just rounding up people. Just rounding them up. No reasonable suspicion, just rounding them up, and then arguing to SCOTUS, once the case reached SCOTUS, that yes, we did consider race, but we also considered the fact that black men especially tend to hang out at the barbershop or at the basketball gym or the weightlifting gym or the street corner. The cultural things that we do. and use those things for the basis of reasonable suspicion. And SCOTUS says, yeah, we'll buy that. We'll go along with that and do just what they did and do just what they did in this case and say, essentially, we're doing it because when we look at the totality of circumstances, there are a lot of drug deals that occur in African-American communities. A lot of the people selling the drugs are African-American men. Those drug deals tend to occur, those sorts of things. And SCOTUS says, yes, that's why I'm taking a hard look at this case to see where this could go, what doors it open. Because there's something I talk a lot about with these cases, and it's a slippery slope. It's once that door's open, it's easy to start going further and further and further down in that direction because of a slippery slope we talk about in the law. You follow me? So this could have broad implications on the African-American community. We already know it's happening because of cases like this. Now, let's look at some more here. So race is a relevant factor. Not the only one, but race can be a relevant factor. In this case, the officers relied on a single factor to justify stopping respondent's car. This is another case. This is the Brignone case, Brignone-Ponce case, the apparent Mexican ancestry of the occupants. We cannot conclude that this furnished reasonable grounds to believe that the three occupants were aliens. So in that case, all that was offered by ICE or INS was that they stopped the car because they noticed Mexican-looking people in the car. And so SCOTUS said, no, that's not enough. SCOTUS said, at best, the officers had only a fleeting glimpse of the persons in the moving car, illuminated by headlights. Even if they saw enough to think that the occupants were of Mexican descent, this factor alone would justify neither a reasonable belief that they were aliens nor a reasonable belief that the car concealed other aliens who were illegally in the country. Large numbers of native-born and naturalized citizens have the physical characteristics identified with Mexican ancestry, and even in the border area, a relatively small proportion of them are aliens. The likelihood that any given person of Mexican ancestry is an alien is high enough to make Mexican appearance a relevant factor, but standing alone, it does not justify stopping all Mexican Americans to ask if they are aliens. Now, if you translate that to and apply it to the African American community with the scenario, the hypothetical that I gave you, then they could very easily just insert all the black cultural stuff in an opinion like this, and very easily say, yes, the fact that the person was black, the fact that the stop occurred in a high crime area, the fact that it was in a place known to be a drug place, the fact that there were little paper bags all over the ground, that was definitely enough for reasonable suspicion. But here's the problem with that. The problem with that is there are a whole bunch of people who live in such neighborhoods who don't deal drugs. But they are black. They live in the neighborhood. They live in places where there's high crime and lots of drugs, not by choice, but because they can't afford to live anywhere else. And so what's going to happen to those people? They're going to be accosted as well. Right? So one of the things that this type of case does is it opens the door for something that a federal judge found unconstitutional a few years ago, stop and frisk. And I did so many videos warning you that Trump, I showed you videos of him saying, stop and frisk, stop and frisk, stop and frisk, stop and frisk. He wants to get back to that. And cases like this will help him. So, it's not that SCOTUS just sanctioned racial profiling. SCOTUS sanctioned racial profiling 50 years ago. It may be getting ready to get upgraded and expanded. But this Brignoni-Ponce case already sanctioned racial profiling when it said that race or ancestry is a relevant factor. Okay? So I didn't jump out on this case. This case has been out there a couple of days. I don't jump out on cases. I like to read them and study them, do some research on them. Moreover, in this particular instance, I knew that this case would impact some of our cases. So I needed to know what was actually said in this case. Now, keep in mind that what Justice Kavanaugh wrote was his concurring opinion in the application or regarding the application. SCOTUS is probably going to get this case once it comes out of the Ninth Circuit, and then they're going to write a merit case, a merit-based opinion, put it that way. They're going to write an opinion based on the merits, based on the record, based on briefing, based on oral argument. And that is actually going to be the opinion. But the things that Justice Kavanaugh said in his concurrent opinion that explain why he voted with the other five, he's basically showing us most likely the things that they are going to say in that permanent opinion. And oh, by the way, one of the other things he said is the plaintiffs are probably going to lose if they ask them to find that the government broke or violated the Constitution, because Kavanaugh explained that they don't have standing, that the plaintiffs don't have standing to bring the case, to have brought the case in the first place. To show standing, you have to show that you suffered an injury, and you have to show that you're likely to suffer that injury going forward. And Kavanaugh said that they probably would not be able to show that even if they suffered an injury, that it would be repeated. So, assuming that he's speaking on the other, on behalf of the other five, Trump is likely to win this case with SCOTUS, thus expanding racial profiling, not starting it for the first, not sanctioning it for the first time, but expanding it, reaffirming it. So the takeaway here is racial profiling has already been sanctioned by SCOTUS on some level. One could argue that the Brignoni-Ponce case only deals with immigration, only deals with Latinos. I, as a lawyer, I definitely would advise against that, because we lawyers take language like that and we use it to apply to our case, a similarly situated case. Okay? All right, so that's my legal analysis of this case. I'm going to include the case so that you can download it in the description. All right? Until the next time, I am Reverend and Civil Rights Attorney Augustus Corbett. Thank you for watching this video. And remember, stay woke.